ಹಲೋ ಅಡ್ವೊಕೇಟ್ ಸ್ವಾತಿ ಚಾನೆಲ್ಗೆ ಸ್ವಾಗತ. ಇವತ್ತಿನ ವಿಡಿಯೋ ಅಲ್ಲಿ ನಾವು ಕೇರಳ ಜುಡಿಷರಿ 2023 ಪೇಪರ್ ಏನ್ ನೋಡ್ತಿದ್ವಿ ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ. ಇದು ಪಾರ್ಟ್ 3 ಆಫ್ ದ ವಿಡಿಯೋ. ಸೊ ಇವತ್ತಿನ ವಿಡಿಯೋ ಅಲ್ಲಿ ಉಳಿದಂತ ಕ್ವೆಶನ್ಸ್ ನ ಸಾಲ್ವ್ ಮಾಡೋಣ. ಅದಕ್ಕೂ ಮುಂಚೆ ಇಂಪಾರ್ಟೆಂಟ್ ಆದಂತ ಒಂದು ಸೂಚನೆ, 1st ಜೂನ್ ಇಂದ ನಮ್ಮ ಹೊಸ ಬ್ಯಾಚ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ. ಸೊ ಹಾಗಾಗಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇರುವಂತ ಪ್ರತಿಯೊಬ್ಬ ಸ್ಟೂಡೆಂಟ್ ನಿಮ್ದು ಫಸ್ಟ್ ಅಟೆಂಪ್ಟ್ ಅಂತ ನೀವು ತುಂಬಾ ಜನ ಕೇಳ್ತೀರಿ, ಆದ್ರೆ ಫಸ್ಟ್ ಅಟೆಂಪ್ಟ್ ಅಲ್ಲೂ ಸಹ ಎಕ್ಸಾಮ್ ನ ಕ್ಲಿಯರ್ ಮಾಡಬಹುದು. ಸೊ ಫಸ್ಟ್ ಅಟೆಂಪ್ಟ್ ಇಲ್ಲ ಥರ್ಡ್ ಅಟೆಂಪ್ಟ್ ಅಂತ ಚಿಂತೆ ಮಾಡಬೇಡಿ. ಅಟೆಂಪ್ಟ್ ನ ಕೌಂಟ್ ಮಾಡೋದಿಕ್ ಹೋಗ್ಬೇಡಿ. ನೀವು ಸರಿಯಾದಂತ ಗೈಡೆನ್ಸ್ ಹಾಗೂ ನಿಮ್ಮ ಸರಿಯಾದಂತ ಪ್ರಿಪರೇಷನ್ ಇದ್ದಲ್ಲಿ ಫಸ್ಟ್ ಅಟೆಂಪ್ಟ್ ಅಲ್ಲೇನೆ ಎಕ್ಸಾಮ್ ನ ಕ್ಲಿಯರ್ ಮಾಡಬಹುದು. ಸೊ ನಿಮಗೆ ಕಂಪ್ಲೀಟ್ 100% ಪರ್ಸನಲ್ ಗೈಡೆನ್ಸ್ ಜೊತೆಗೆ ನಿಮ್ಮ ಕಂಪ್ಲೀಟ್ ಸಿಲೆಬಸ್ ನ ಕವರ್ ಮಾಡಿಸುವಂತ ಜವಾಬ್ದಾರಿ ನಂದು. ಸೊ ಹಾಗಾಗಿ 1st ಜೂನ್ ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಿರುವಂತ ಬ್ಯಾಚಸ್ ಫಾರ್ ನಾಮಿನಲ್ ಪ್ರೈಸ್ 5,000 ರೂಪೀಸ್. ನಿಮಗೆ 10 ಫುಲ್ ಲೆಂತ್ ಮಾಕ್ ಟೆಸ್ಟ್ ಸಹ ಸಿಗತ್ತೆ. 100% ನಿಮಗೆ ಪ್ರಾಕ್ಟೀಸ್ ಕ್ಲಾಸ್ ಅಲ್ಲೇ ಮಾಡಿಸಲಾಗತ್ತೆ. ಸೊ ಇದೆಲ್ಲ ನಿಮಗೆ ಕೇವಲ 5,000 ರೂಪೀಸ್ಗೆ ಸಿಗಲಿದೆ. ಅಂಡ್ 1st ಜೂನ್ ಇಂದ ಬ್ಯಾಚಸ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇರುವಂತ ಪ್ರತಿಯೊಬ್ಬ ಸ್ಟೂಡೆಂಟ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತ ವಾಟ್ಸ್ಆಪ್ ಲಿಂಕ್ ಮುಖಾಂತರ ನೀವು ಗ್ರೂಪ್ಗೆ ಜಾಯಿನ್ ಆಗಿ ಕ್ಲಾಸ್ ಲಿಂಕ್ ನ ಪಡ್ಕೊಳ್ಬಹುದು, ನಿಮ್ಮನ್ನ ನೀವು ಎನ್ರೋಲ್ ಮಾಡ್ಕೊಳ್ಬಹುದು. ವಿಡಿಯೋನ ಕಂಪ್ಲೀಟ್ ಆಗಿ ನೋಡಿ, ಸೊ ದಟ್ ನಿಮ್ಗೆ ಕಾನ್ಸೆಪ್ಟ್ ರಿವೈಸ್ ಆಗತ್ತೆ. ಹಾಗೂ ಇದು ಕೇರಳ ಜುಡಿಷರಿ ಪೇಪರ್ ಆದ್ರೂ ಸಹ ಕರ್ನಾಟಕ ಜುಡಿಷರಿಯಲ್ಲಿ ಈ ಕ್ವೆಶನ್ಸ್ ನ ರಿಪೀಟ್ ಆಗುವಂತ ಸಾಧ್ಯತೆ ಹೆಚ್ಚಾಗಿರುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ವಿಡಿಯೋನ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಎಂಡ್ ತನಕ ನೋಡಿ. ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ ವಿಡಿಯೋ. ಕ್ವೆಶನ್ ನಂಬರ್ 51. The offense alleged against the accused is under section 138 of the Negotiable Instrument Act. When the matter was taken up for recording the plea of the accused, the magistrate was convinced that the materials were sufficient to constitute the offense. The magistrate therefore stopped the proceedings under the section 258 of the CRPC and discharged the accused. The order is dash. So the order is incorrect since it is a complaint case. Question number 52. The magistrate shall, as the examination of each witness proceeds, make a memorandum of the substance of the evidence in the language of the court. This procedure applies to summons case. Question number 53. Pardon under section 306 of CRPC can be tendered by a chief judicial magistrate at any stage of the investigation or inquiry into or the trial of the offense, whereas pardon can be tendered by a judicial magistrate of first class at any stage of the dash. It can be tendered at any stage of the inquiry into or the trial of the offense. At any stage of inquiry, judicial magistrate first class can tender pardon. Question number 54. A magistrate recorded part of the evidence during the trial of a case. The successor magistrate may act on the evidence so recorded by his predecessor if it is a summary trial. Second, it is a case transferred for want of competency to the predecessor magistrate. ಇದಕ್ಕೆ ಕರೆಕ್ಟ್ ಆನ್ಸರ್ is 1 and 2 both are incorrect. ಎರಡು ಆಪ್ಷನ್ಸ್ ಸರಿಯಾಗಿಲ್ಲ. Question number 55. Section 354 clause 4 of the CRPC says that when the conviction is for one offense punishable with imprisonment for a term of 1 year or more, but the court imposes a sentence of imprisonment for a term less than dash, it shall record the reasons for awarding such sentence unless the sentence is one of dash or unless the case was tried summarily under the provisions of the code. So correct answer bandu question number 55 is option D. For a term less than 3 months, it shall be recorded its reasons for awarding such sentence unless the sentence is one of imprisonment till the rising of the court. Okay. Question number 56. 90 days is the period provided for completing the investigation, failing which the accused is entitled to get default bail under the proviso of section 167 clause 2 of CRPC. If the offence is punishable with imprisonment for a term not less than 10 years, in which case Supreme Court of India interpreted that the period of imprisonment for the above purpose shall be minimum 10 years. It was interpreted in the case of Rakesh Kumar Paul versus State of Assam 2017. Question number 57. An accused was released on bail, failed to appear before the magistrate on successive dates of posting. The magistrate, invoking the provisions of section 446 of the CRPC, issued notice to the sureties calling upon them to pay the penalty or to show cause why the penalty should not be paid. The sureties appeared and contended that the action taken against them is illegal since no notice asking them to produce the accused was given. Decide. So correct answer here will be action is legal since section 446 of CRPC does not contemplate such notice. Question number 58. In a dash offence, accused can be arrested by the police officer without a warrant. So in a cognizable case, accused can be arrested by the police officer without a warrant. Question number 59. Criminal misappropriation of property is the offence. Magistrate convicted and sentenced the accused to the maximum prescribed sentence of 2 years imprisonment. The accused was not heard on the question of sentence. Did the magistrate go wrong? The magistrate, no, since it was a summons case. Question number 60. Punishment prescribed for an offence under the special statute is imprisonment for a period of 7 years. There is no provision in the statute stating which court has to try that offence. If that offence is triable by which court? If that offence is triable by judicial magistrate of first class. Question number 61. Section 300 of IPC defines murder. It does not express that a child under 7 years of the age cannot commit murder. If so, why do we say that section 82 of the IPC, which expects acts done by the child under 7 years of age from the purview of offences, applies to murder and other offences under the penal code? By the application of section 6 of IPC 1860. Question number 62. Section 84 of the Indian Penal Code says that nothing is an offence which is done by a person at the time of doing it by reason of unsoundness of mind is capable of knowing the nature of the act or that he is doing what is either wrong or contrary to law. Question number 63. 5 persons stood trial on a charge under section 143, 147 and 148 and 326 read with section 149 of the IPC. The magistrate acquitted all the accused, holding that the prosecution failed to prove the involvement of 5 persons but proved the involvement of only 2 among them, and they together did the crime. Choose the correct remark from the following. Magistrate could have convicted those 2 accused. Question number 64. A made a false entry in the account book for the purpose of using it as evidence to support his claim in a suit and produce it in the court. What offence would thereby be constituted? A. Fabrication of false evidence. Question number 65. A taxi driver picked up a quarrel with the accused on the taxi fare. The injured intervened and tried to stop the quarrel. The accused fisted the injured on his face. He received a bleeding injury and lost a tooth. What is the offence committed by the accused? The offence committed is voluntarily causing grievous hurt on the sudden provocation. Question number 66. The accused forcibly grabbed the arm of the victim aged 25 years, dragged him into the car and took him to the house of the accused 5 kilometers away and after 3 hours left him off. What offense had the accused committed? So the accused has committed the offense of abduction, assault and wrongful confinement. Question number 67. A theft becomes robbery if, in order to the committing of the theft or in committing the theft or in carrying away or attempting to carry away property obtained by the theft, the offender for that end dash. For that end voluntarily causes or attempts to cause any person death or hurt, voluntarily causes or attempts to cause any person wrongful restraint, voluntarily causes or attempts to cause to any person fear of instant death or of instant hurt or of an instant wrongful restraint. So you can answer all of the above. Question number 68. A gang of 7 persons committed dacoity and murder. They shall be sentenced separately for murder and dacoity with murder. Question number 69. A finds a purse containing rupees 10,000 lying on the public road. A took it. Afterwards, he knew that it belongs to another. However, he spent the money. Has he committed any offense? S. He has committed criminal misappropriation of property. Question number 70. Which among the following combination constitutes an offense of cheating? A. Deception and delivery of property. B. Deception and fraudulent or dishonest inducement. C. Deception, fraudulent or dishonest inducement and delivery of property. D. Fraudulent or dishonest inducement and delivery of property. Correct answer: deception, fraudulent or dishonest inducement and delivery of property. Question number 71. Choose the provision of Indian Evidence Act which makes the report of a test identification parade relevant. So section 9 of Indian Evidence Act speaks about test identification parade being a relevant. The inscription on a plaque placed on the bridge at the time of its inauguration is dash. It is documentary evidence. Inscription ಆಗಿರೋದ್ರಿಂದ. Question number 73. A filed a suit against B to restrain him from trespassing on the land of A. B alleged the existence of a pathway along that land and he succeeded. Subsequently, A filed a suit relating to the same land against C. What is the use of the judgment in the suit between A and B in the suit between A and C insofar as the existence of the pathway is concerned? The judgment is relevant. Question number 74. Choose the incorrect statement. In a criminal proceedings, the fact that the accused person is of good character is relevant. Correct. In criminal proceeding, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. Correct. So option C. A previous conviction of the accused is relevant as evidence of bad character. True. D. In criminal proceedings, the fact that the accused person is of good character is irrelevant. False. So, hagagi incorrect statement is option D. Question number 75. An attested document which is not required by law to be attested may be proved if it was unattested. Okay. So, ಇಲ್ಲಿ ತನಕ ನೀವು ವಿಡಿಯೋನ ಕಂಪ್ಲೀಟ್ ಆಗಿ ನೋಡಿರೋದಕ್ಕೆ ತುಂಬಾ ಥ್ಯಾಂಕ್ ಯು. ಅಂಡ್ ಈ ರೀತಿ ಇನ್ನಷ್ಟು ವಿಡಿಯೋಸ್ಗೆ ಇದರ ಇನ್ನೊಂದು ಭಾಗ ನೆಕ್ಸ್ಟ್ ವಿಡಿಯೋಲಿ ನೋಡೋಣ, ಉಳಿದಂತ 25 ಕ್ವೆಶ್ಚನ್ ನ. ಸೊ ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ದಲ್ಲಿ ನಿಮ್ಗೆ ಜಾಯಿನ್ ಆಗಬೇಕು ಬ್ಯಾಚ್ಗೆ ಅನ್ನೋಂಥ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ದಲ್ಲಿ 1st ಜೂನ್ ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಿರೋಂಥ ಬ್ಯಾಚ್ಗೆ ನೀವು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋಂಥ ವಾಟ್ಸ್ಆಪ್ ಲಿಂಕ್ ಮುಖಾಂತರ ಗ್ರೂಪ್ಗೆ ಜಾಯಿನ್ ಆಗಿ ನಿಮ್ಮನ್ನ ನೀವು ಎನ್ರೋಲ್ ಮಾಡ್ಕೊಳ್ಬಹುದು. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ಅಂಡ್ ವಿಡಿಯೋಸ್ ಇಷ್ಟ ಆದಲ್ಲಿ ನೀವು ಲೈಕ್, ಶೇರ್ ಹಾಗೂ ಸಬ್ಸ್ಕ್ರೈಬ್ ಖಂಡಿತ ಮಾಡಿ. ಥ್ಯಾಂಕ್ ಯು.